Worst one we ever had it, we had a snap come in where it was the high was -10. And that's the one I remember. So anytime I think of that place, it's like that's what I remember.
Until like the end of August here.
Mhm.
The hottest it'll get is like 67.
Yeah. Yes, that's what it was in Illinois. It's like it might get into the 90s there. And here it's like 110. Yeah. Yeah. You keep going. I didn't know it went over 100 and stayed there. Mhm. Those just in case. Let's see. So this is Crim Law. One, we are only 4 minutes out. 4 minutes out. So if you're watching this after the fact, also note that today at 1 p.m. here, Wilson Hall 255, we are having a 5-year program review. They want to meet with you. We'll talk about that for just a quick second because I forgot to mention it last week and we didn't meet Monday. I was running late. So I was extra scatterbrained on Monday. And then, oh yeah, I forgot to send out announcements. And then so the first ones went out yesterday, and then I sent another one this morning so people are aware that's going to take place. That we have this event coming up at 1 p.m. today. You can be here in person if you like that, but if you wanted to sign in through Zoom, that's an option too. And so basically what it is we're having a 5-year program review of both our bachelor's and master's program. And our outside reviewer is one Dr. Rick Pulvers from University of Texas at Tyler. So this is my first time actually taking part in this kind of process at one at this university, but two in this manner. So my previous university, when we did program reviews and assessments and that kind of stuff, it was all internal. So I'm really excited for this. I really want to see what kinds of questions come up and that kind of stuff. So try to be here because I want to see where the conversation goes. It's one of those things. That process, that peer review process, is one of the things that keeps us aligned and moving in the right direction. And if it goes off, like in a tangential kind of thing, boy, does it go off. Sort of like if you guys ever get on like YouTube or any of those, well, YouTube's probably the best one to find all kinds of sources of information. My favorite one is related to where things have gotten off, and it's out of I think it was Oregon Northwest kind of region of the United States. A bunch of psychologists. I can't remember what group it was. Basically, what it was is they published a bunch of false studies to test the journal process, that peer review process. They were testing ideology over, I guess, actual statistics and logic and reason to some degree. And what they found was kind of scary. And so the more people we get involved in these processes, the clearer they are. You can get some more, one, better results, two, more good things. Let's see here, Stephen. All right, let's let you in. All right, so we are 1 minute. Open up where we're at, because I think we're getting ready to move into deaths. Matters of life and death. No, it's not mandatory for here, but if you're in evidence, it's at the same time. So for them, it kind of is. They'll get bonus points for attending, but they'll want to be there because that's when their normal class time would be. And so if they skip out, it'll be like, hey, You should have been here regardless. What's going on there? Do this again. All right, where's it at? 7:03. Get this going. It is officially 9 o'clock. So, as you can see on the screen on that whiteboard, I put up some information about a meeting that's taking place today at 1 o'clock. If you're paying attention to your email, you'd have gotten an announcement through Blackboard about it. I sent one out yesterday. Maybe yesterday evening. I don't even know what together for me. I sent it out again this morning so it was fresh in people's email. Basically, what it is we're doing a 5-year our bachelor's and master's programs, and so you all are invited to be there. Let's see here. So that person gets in. So if you can be there, they'll be literally in here. If you can't be here, great. If you can't be here physically and you still want to participate, there. So that's got a Zoom link there that you should be able to click into. And then if you can't make it, that makes me sad because I want you here. Basically, what it is it's an outside faculty member from a different institution who's been reviewing what our processes are, and now they want to talk to you. The most important thing here. And so that information's now presented to you and mentioned it in class. So I feel like I've done my job in notifying you all. Yeah. Now you just need to be here. But if you can be here, this information is in your email as well. And on in Blackboard, if you look under announcements, if I remember correctly. Let's see, Crim Law 1. Let's make it a little smaller. Yeah. Admit. And so I need to grab. Let's see where we were at. That one. Downloads. This is going to be. Wait, we're not as far as I thought. Nope, there's 3. Elements of crime we've already covered. There's 3 anticipatory offenses. So parties, we need to talk about parties and then RICO stuff. So I remember I was skipping around a little bit. So attempts and solicitations we were talking about. Conspiracy we started talking about. Let's see. We were talking about those limitations a little bit. Pinkerton rule. We talked about how much had we gotten into conspiracies? Do you guys remember? I don't. Keep your guys a little bit. So big things about conspiracies is one is it's more than it's one, the agreement, but it's the agreement for the purposes of something criminal in nature. You have to have 2 distinct parties outside of the crime itself. Well, 1 plus 1 for whatever it takes in terms of the crime itself. Because it's a 2-party crime, just having those 2 parties agree to commit the crime before they commit the crime. It's not really a conspiracy if the crime requires 2 people. That kind of thing. They conspired to do it, they just did it. That kind of thing. When you start looking at some of the limitations there, of course, that's some of the ways that we break people up in terms of groups. If you're dealing with organizations, that's one thing. If you're dealing with, let's see, I don't remember exactly which rules we haven't talked about yet. So when you start getting into it, part of it is related to, ooh, 1 second. Boom. Criminal actions and criminal liability there because of the agreement. As soon as you have something that furthers it along, that's the point at which you can actually go after it. And you also start moving into where the responsibility for criminal actions start transferring among people, even though they might not have been directly involved into it. The specific crimes there. So 2 or more persons conspire if they commit a crime, falsely or maliciously indict another for any crime. So that's to basically frame someone. Move or maintain any suit or action or proceedings. That's you're using the government there for the same kinds of purpose. To cheat or defraud persons of property, or by any means cheat them out of money. So basically you're going after resources there. So it's fraud again that they're going after because that's what conspiracies tend to go after. Money, resources. And then commit any acts injurious to public health, public morals, trade, commerce, all that kind of stuff. That's more of an aggregate level. So if you're not going after someone in particular, but you're still having an effect on the industry that's conspiratorial in nature, you can go after it that way. Except in cases where different punishments prescribed by law. So if in case they've got specific conspiracy statutes on specific crimes, you'll go over here. Okay, so parties to the crime. We were talking a little bit about this. There's some distinction there between, well, whether you're directly involved or not, and how much you're involved, how much you're aware of, can make you a party to the crime, even though you're not directly involved in it, right? And so that's the distinction we're trying to make there, is how direct is your involvement? Is it indirect or is it direct? If it's indirect, you're an accessory. If it's direct, you're a principal. But you have some gray areas there, right? So, is present actively or constructively. So you don't actually have to be there. Your just presence has to be there in terms of what you've done. Or is it not there? You make that distinction. Okay, then when is it you're an accessory to it? Before or after the fact? Before is you know what's going to happen. After the fact is you're aware of what has happened. Right? Be like giving shelter to someone who's on the run. Are you an accessory for their fleeing? Are you aware that they're on the run? Is it reasonable for you to know that? That kind of a thing. Okay, accomplice liability. It's necessary. This is actually a particularly important sticking point because in most places, you'll need to find the initial criminal guilty, right? If there is no crime, there is no criminal, there is no accessory, right? That's a procedural thing that's very, very, very important. What do I want to say about that? You can see big particular issues with that in terms of stuff going on in the world right now on the federal level and states. So there's a little bit of a federal state dispute in terms of unofficially, if you're paying attention, there was some news that was related to the assistant director of the Department of Justice was saying something to the effect of some felonies that were pushed on the state level or miscarriage of justice because the initial crime was never established. You don't have the initial crime, hush money and stuff like that doesn't exist. It's not hush money, it's just payments. And so that's a technicality. And so procedural violations, due process issues. Yeah. That's not good. So first thing you find out, is it necessary before you move forward? Some states, yes, some states, no. Right? As a rule, you'll want yes. Okay. Act and mental state, we've talked about to some degree. Wharton rule we've already talked about. Defenses, abandonment. Scope. What does that mean? Talk about scope. We've already talked about it in terms of how it transfers over. When it transfers over. Defenses, abandonment. Again, just like the other attempts and stuff, you need to be able to clearly substantiate that. This is one that, yeah, that's basically what we need to do there. Any assistance there that you've provided. Okay, here it is in terms of criminal statutes here. Classifications of parties, principals, and accessories. Principals, all persons concerned in the commission of crime, felony or misdemeanor, directly committing the act constituting aid and abet in this commission, though not present, are principals. So you don't have to be present, right? All persons after the commission of felony conceal or aid knowledge. The intent that they may avoid. So that's the way that's gonna have it set up here. So if it's before the fact, you could be classified as principal here. Okay, RICO. Basically, like I think I mentioned this a little bit when we first started talking about the conspiracy stuff. So this is the going after large organizations, basically mafia stuff is where most of the stuff takes its roots. So it's designed to go after revenue streams because that's what they were doing, right? It's all about money. So use of income derived from pattern racketeering to acquire interest in enterprise, acquiring to maintain interest in the enterprise through pattern racketeering activity. So are you gaining your start in there? Are you getting your income from it? Are you maintaining interest in an enterprise? Are you affecting an enterprise? Or are you conspiring to do any of those things? You start falling into RICO, right? And so it's industry you start affecting, that kind of stuff. Large money there. Huge effects. And so what you do there is you seize the money and you transfer that liability across people for criminal actions. State RICO, it's on the next slide. That's a small one. And so it gives you some of those things. It starts talking about beneficial interest. So you start getting into things like, okay, are we talking about trusts? Are we talking about other, whether it's titles, whether it's property, whether it's enterprises, businesses, all of those types of things, that whole aspect of basically revenue. There you go. So to get the pattern, what you need there is a little bit different than conspiracy, where you just need to be establishing or furthering it. This one, you need that pattern of two things to show, right? And so 2 occasions of this, you have your pattern, you can go after the whole thing. Okay, and it even has a date there from when it starts, 1988. So that's less important for these days, but that's in there. Okay. They need to be related to the affairs of the enterprise, not isolated and not so closely related that they are a single event. And so that's how they start to make those distinctions there. You need to be able to identify that they are 2 separate things. That's all what they're saying. That's all that they can say, because if they get any more descriptive, you start affecting your ability to use it. All right. And so that gets us through that one. 4th one. Guess I haven't downloaded that one yet. We'll start with PowerPoint. Defenses. I don't know if I want to talk about life and death. We'll go into defenses. Okay. So I'm going to skip some of this stuff because I want to talk about the heart of the matter right here. When you start talking about defenses, basically what you start dealing with is the big one is you poke holes in the prosecution, right? You introduce enough doubt and they can't convict you. Another way that you do it is affirmative defenses. You're introducing some type of evidence, some type of argument that if you can substantiate that, whether it's a full or a partial defense take place. Full defense is an acquittal. A partial is a reduction in charges. So the first thing you do is you start attacking the mental element, that element of mens rea. That's kind of what they're getting at for this stuff. And to some degree, self-defense. I can't remember that exact case because there's been so many since. We'll focus on that mental illness stuff because it'll focus in on the same kind of thing. So depending on how you view it, you get at some of the basic underpinnings of this country. And so in procedures, I ask a certain question. I'm going to ask it here because it kind of relates to this kind of thing here. If you're doing something criminal and something happens in the process of your arrest that massively violates your rights, we tend not to use the evidence that we have acquired against you and prosecute you because of the fact that your rights were violated. Why do you think that is? It is just as easy to still use that stuff against people. In fact, if you want to look at tyranny or if you want to look at the history of this country, you'll see that that's happened overwhelmingly as the case. Right? Only within the last few generations, a few hundred years max, we started to learn the role of mercy and the fact that if we dial back on things, life gets better. That question asks you at the very base of that. Basically, what you start getting at there is how we weigh which transgressions matter. Yes? We're dealing with police officers. It's pretty easy to identify. It's like, if that person's speeding, yes, you pull them out of the vehicle and you start beating them senseless. That's not right. That's 1992, right? And of course, drugs and intoxication, DUI, and resistance, that too. But if you were to watch that video, you're like, that ain't right. That ain't right by a long sight. Right? We start looking at things like insanity, mental illness. Is the product of the action something that we're going to hold that person responsible for? That action. They've got a mental defect. They still produce the action. What are we holding responsible here? The person or the illness? Draw that one in at some point. How do you do it? It's interesting because depending on how you want to view that question, how you view the previous question, and how you view other, whether it's mental issues or things like that, this entire aspect of this system is a question, right? Because it's now the product of that illness only. You're not holding that person responsible. You need to be able to substantiate that. Otherwise, that's going to be something you're going to look to substantiate across other things or strengthen or weaken in terms of the society so its understanding decreases. It's a different discussion. Interlace this issue with sex crimes against children. Right? There are significant arguments taking place in certain places in the country where that's viewed as a sexual orientation. Mental illness, maybe. And as you have that shifting of society, some of these lines can be redrawn if there's enough people to make that decision that direction. That's how that works. It has to balance itself. So realize this is the question that's taking place underneath of this argument, right? When you start making that insanity defense, yes, it's an affirmative defense, but as you're going, keep in mind that you're dealing with people who are making a number of decisions related to what actually occurred and how it all fits together and how it all matters. So to some degree, they're going to look at it both ways, right? So you need to be able to clearly establish what it is you're trying to do there. Here's how we do it. So, it actually jumps into other ones before it jumps back into insanity. I might jump into insanity, talk a little bit about that first, and we'll talk about some of the other types. So we start getting into insanity, there's a number of different tests that can use across the problem. And so whenever you get into any specific state, what you need to do is you need to look at to see the specific statutes to see how they fit, because to some degree they're going to be individualized and they might sew different elements across these into that specific statute. So you have to know exactly what it is that's asking for. The general ways that they classify it, insanity versus mental illness, that kind of thing. That's kind of the societal one. We start getting into it. You got the M. Naughton rule, the irresistible impulse, and Durham rule, the product. I think there's another slide where it goes into more. And so M. Naughton, right versus wrong. Do you understand what those things are? If this was wrong, if you don't, then how can you understand that why we're punishing you? Right? Irresistible impulse. You know it's wrong, but you can't control it. Right? Think someone has epilepsy. Think of it this way. They don't know they have epilepsy. We'll put them at your age. They're behind the wheel. They're driving between here and the next big town, right? And then they crash into somebody. They run somebody over. A walker, right? It's not their responsibility for that. They have no way of knowing. You might know that you have a mental illness or something like that, but what's your ability to control the effects of it? Durham rule. This is the product rule. Accused is not criminally responsible if the unlawful act was a product of mental disease or defect. So it's the direct result of that. That's a little bit different than let's see here. So more on the next slide. Yep. So substantial capacity. Okay. Inability to appreciate the fact that the act is wrong or to conform their conduct to law. So that's where we start to integrate the two of those other tests, right? See that, okay? Can you understand that it's wrong or can you control it? And then the mental, guilty but mentally ill, sort of mental middle ground, the mental and middle. Can't say those two words back to back. Middle point for those types of issues where, yes, we're going to hold you guilty to some degree, but yeah, you were found to be mentally ill, so we're going to dial it back for some reason. Well, for that reason, to some degree, right? Must receive psychiatric treatment, often psychiatric facility rather than a prison. When you start getting into those types of punishments, that's one that's kind of interesting too. Like the people who don't think about it too much. Whenever you see people get this kind of sentence, and if it's the sentencing where it's no punishment whatsoever, but only hospitalization for treatment, that kind of thing, it's like, realize that the kind of treatment you get in these facilities right here can be worse than what you get in the actual prison facilities as you start bringing in medical procedures, right? And so just think about that. Some jurisdictions have abolished this as a defense. That kind of thing. Okay. Then we'll go back to some of the other ones. Okay. Ignorance or mistake. It's not generally a defense, right? Unless it's something that there's been a change there and there's not been proper notice, that kind of stuff. Right? That's why they do that. I think I mentioned that before. Also, why not a bit because I'll just give you some issues. Okay, duress versus necessity. Same kind of situations. Duress is caused by people. Necessity is caused by situations, right? Someone abducted one of my kids, is holding them at gunpoint, so I robbed the bank. I'm going to go rob the bank. I'm not responsible for robbing the bank. I had no choice, really. I mean, I had a choice, but not really. Necessity, when we start looking at that one, basically what you get there, similar kind of situation, only it's not a person. I have to do this. It is necessary from the situation. It could be life or death. The circumstance I like to give is you're lost out in the woods and you come across a cabin. There's no one there. Do you break in? Of course you do. If you're in areas that have up north where it's rural, there's specific exceptions carved out into the law because that's going to be something that happens to people, especially like hunters and stuff like that. Right now. All right. Infancy. This is the one that's really interesting. The incapacity for children to form criminal intent. Let's talk about that one for a second. So what are they saying there? Infancy, what is it? Okay. Do you agree that at a certain age you can't appreciate the wrongfulness of your actions or the gravity of them? If you're 8 years old, you're playing with your pop's loaded firearm and it goes off and hits someone. Do you know what you've done? No, right? So to some degree, you'd say yes, this does exist. Our ability to understand things, time, age, experience, that, right? Understand. You agree with that statement? Makes sense. Makes a lot of sense. So where do we draw the lines for that? When is it you should understand that what you've done is wrong and for what things? When can you appreciate that if you take this sharp object and you start poking it into somebody and they leak out like a water balloon, that that's a bad thing? What do you want to hold them responsible for it? 17? You knife somebody in a bar, snuck in. You don't want to hold them responsible for that? You're 17? You'd let them go? They hunted somebody down. It was a 6 foot tall white male. He was hunting down a 5 foot tall female who had also snuck into the bar. She was 16. Starting to feel like doing something about that now? Maybe a little bit. Yeah. So there's some discussion here in terms of who we want to hold responsible for what and at what ages, right? Who is going to depend on what? What are we talking about and their age, right? And so depending on the specific state you're in, there'll be some lines that they draw. Some will be hard lines. I forget what they are. It's like 7 or 8 for most criminal things, because if you're under that age, it's like you're not going to understand it. Somewhere in the neighborhood of like 14 or so, they start making decisions as to whether or not you're going to be an adult. Right? Of course, you have a whole juvenile system to deal with them because they are different. My question is, where is this the limit? Where do we say that infancy no longer exists? Because that's one that's not going to be in this. That's going to be one that's going to be found in you. That's going to be the societal things. Those are softer measures you won't necessarily see here. I'll show you some stuff that you will think is kind of funny. I think it's funny because it's contradictory. Okay. So we'll take these things into account, your age into account, to what point? At what point do we no longer say that this should be a consideration? Okay, and that's a different question. When are you no longer infants? When are you no longer children? When are you, instead of doing the negative, when are you considered adults? You guys not answer that question? That's a bigger societal problem, isn't it? Because you can already see that this is starting to change some in some different ways, right? You start dealing with the societal things and where it's going to affect here first. Official processes, 18, right? Is this the point in time when all decisions open up to you as an adult within our society? Okay. What are you talking about then? Okay, this is an interesting one. Because it doesn't necessarily go into law, but it does. Because you'll see its reflections in law in different directions things move, right? To some degree, how are we going to hold people responsible at what ages, right? To some degree, there's your hard number. What was it last week? We gave a talk on, I think it was on Monday, for a group communications group. And I love contradictions. It was about speech and freedom of speech. And so I pulled out this right here. Like, I love this because it's contradiction. This is something we regulate, but why? Some people don't spit. Okay. We regulate cigarettes and vapes and all that stuff because it affects your air quality. You breathe it. So if I breathe it, you breathe it. You're not breathing this. This is in somebody's mouth. Why do you want to control what's in their mouth and what they consume? Where are the adults? I got a complaint before too. That's what's kind of funny. Yes, that's the problem. It's control. When is it you want to control something? That's the underlying message here, right? You have some hesitancy here with this one. You should. You have some hesitancy here. I understand why, right? Because this thing's shifting around. The one I really like to talk about is this age and your that one. That's constitutional right. We regulate and we'll give you full access to it. They don't even give you full access to it. We give you more access to it, the most useful aspects of it after that age. So when you're most vulnerable in this time period, the most easily usable one in terms of access, you don't have access to. Those are handguns. Those ones are used in self-defense. Those are the ones used in criminal actions. It's not going to be your rifles or shotguns. You're not adults. They're taking that away. That's one of those things that's really interesting. Start looking at other topics as we start moving on. The other one that we'll talk about, probably it'll take us probably about 3 weeks to get there, is when we start moving to sex crimes. This one right here, plus that thing I was talking about. Attracted persons is the way it's being vetted out in some places as a mental disease. It's a defect. In the places where they have this conversation going on, they are simultaneously having conversations about sex crimes, when to consider them sex crimes. How much of an age difference is there? And what does it need to be before you consider this not a crime at all? Right? The way they have it set in California is where they've started to change things. This right here. Victim. We'll say her. Right? Age ranges. Historically, if we're getting into, we talk about Romeo and Juliet laws, which are like 2 to 4 years kind of thing. If you think about, like, I guess high school is a social convention they're basing that off of to some degree. Well, this thing out there, it's this. 10 years. 14, 24. The age ranges they're currently playing with over there are whenever you need to be added to the sex offender registry. When is it mandated that we need to identify you as a sex offender after you're convicted? Right? The way it's written, there's an age gap that's less than 10 years, perp is under 24, or I should say is 24 or younger, and the victim's 14 or older. It's a decision for the judge to make. Okay? That is not mandatory. Stop and think about that for a second and think about where you're at in your ages right now. In the educational environment, this one is someone who's potentially postmasters. This person's someone who's a freshman in high school. Maybe. That's disgusting, right? Yeah. Yeah. Those are the battles that are going on right now. You guys aren't aware of because no one talks about it that way. Interesting stuff, right? It's moving in different directions on different things, depending on the topics are and the way that they interact. That's where it's really at. Yeah, it's disgusting. All right. So that's infancy. Ignorance, mistake. We talked about that. Duress, necessity. We talked about insanity. Diminished capacity. That one I should have talked about when we were talking about insanity defense. Basically, we start getting a diminished capacity. Is there some reason why you can't? Your mental functioning is decreased. Your intent level is not going to be there. I don't want to talk about intoxication here just yet, but that can be an example of this. Basically, what happens there is you can still be held partial responsible. You can understand that what you're doing is wrong, but not the full nature of it. Like when we start talking about like intoxication as a defense here in a second, same kind of thing. It's the reasonableness of the actions that you take while you're intoxicated. If you could have foreseen those happening, yeah, you're going to be responsible for that. Sort of like drunk driving. You chose to get drunk. You knew you had this as an option, and you did not prevent it from happening. You chose that. Foresight there is pretty easy. Automatism. Basically, what you're getting there is unconscious actions. They mentioned emotional distress is the clear one there. I'll mention one that's kind of off topic, kind of weird because it's got stuff going on. That would be like Ambien. I've been taking sleeping pills. I'm sleepwalking now. Am I responsible for my actions? I got in my car and I rode somebody down again. It's like, oh, yeah. You have epilepsy. You know you have epilepsy, but for some reason you chose to get through the wheel. You had a seizure. You're responsible for that. You did that. Yeah, you don't control the seizure. You controlled everything else. Let's see. Emotional trauma is another example because you can overwhelm somebody to the point at which, yeah, you can't process anything. You're just reacting, right? If you present someone with, what was it? A few years back, it was one that it wasn't a death case, but it was a severe beating. think it was in Texas. It was like public bathroom, kid goes in the public bathroom, takes a little too long. Dad goes in to see what's going on. And kid was being molested. He beat the crap out of the molester. I mean, almost to death. No charges. Why? That's going to be this thing right here. Yeah. You were in charge of that person. As soon as that gets in front of anybody, they're like, oh, hell no. Yeah, I'd do the same thing. See ya. Go have a good day. Entrapment. That's an interesting one because there's a couple different types. Okay, it doesn't, and it starts to go a little bit into it there. So the two different tests for entrapment, there's a objective and subjective. Basically, what we start looking at is you look at the state statutes again. What they'll do is they'll mix two different elements. Subjective, your criminal history matters. Objective, we focus more in on the actions of the governmental agents involved. Example, subjective, I'm a drug dealer, right? You brought drugs to me and asked if I'd run them around for you. So yeah, I have no defense for entrapment there because I've got that established history as a drug dealer. Or I'm a prostitute and I trick you into prostituting, or I get tricked into prostituting myself again. Yeah, I can't be entrapped in that. That's my MO kind of thing. The objective ones where we start getting into the actions of the government themselves. They talk about induction. So basically what you start getting in there is where does the idea originate? That's really what they're trying to get at. Is the idea something that really originates, resonates within that one person who we're trying to charge, or is it something someone else put there? To give you the example, the landmark case for that one, I can't remember the name of it, but basically what it was is it was child pornography case. Basically, this is back in the 90s, if I remember correctly, mail order. So that kind of thing. Governmental agents involved, they were sending, what do we call those things? Advertisements, like pamphlets of advertisements for all kinds of sexually explicit materials to include children. And after doing that for over a year, the person finally ordered one. That's a year of you constantly saying, hey, why don't you order something? Hey, why don't you order something? Hey, at some point in time, that's no longer that person doing it. It's the fact that you're presenting it as an opportunity, right? This is something that's kind of a difficult thing to start getting into a lot of agencies where they start getting into their actions and how they set up stings. It's like you start getting into these territories in terms of the way people look at them, whether or not they are different distinctions. Where you run into problems, how much effort, how many officers, and that kind of thing. Just from the outset, you start to get into issues. That's another one that's been the politics side. I want to say that was in 2020. Was that Michigan, where they had a conspiracy plot to kidnap and potentially murder Michigan governor, right? Turns out there's over half a dozen federal agents, and I think only like 2 or 3 actual people involved. And so how many people were there talking that person into it? And how cavalier was there? Like, okay, I'm just going to go along with you crazy guys, right? And so that becomes one of those questions, one of those problems. So long as you're identifying what those measures are, there you go. When we start talking about outrageous government conduct, that's actually something that's got some standards there too. What kinds of things would they include in there? The best one there is, I think it was the 1980s. That's going to be a case where guy gets his stomach pumped forcibly. Yeah, so drug bust kind of thing. Go into someone's home as they're going to arrest the person grabs something, pills off the table, swallows them. Okay, we can take that. We can get that back. I had a search warrant for that anyway. So it's another documented stomach pump. And if you don't know anything about stomach pumps, that's not a fun experience. Not at all. And so that's kind of behaviors you can get there. We're going to forcibly pump stuff in your stomach, like you vomit a whole bunch, flush everything out. Just to get evidence to use against you, we're going to put you through torture, because that's what that is. That's what that is. Okay. Defensive purposes and property. This one's always an issue. Depending on the state you're in, it varies so widely. This one I should probably talk a little bit about too. We got 10 minutes. I'll probably stop with this one, depending on how far we get. Now we talked a little bit about that. Consent. We'll talk about that one too. So we might stop with that one. I don't know how fast I get through defense. So in terms of thresholds there, probably the best way to set it up is bookend it. On one end of the spectrum, you have the you stand your ground kind of doctrines in place in some states. Others, you have this one over here, duty to treat. I grew up in Illinois. It was this way at that point in time. I don't know what it is now because I've not lived there in 20 years, more than 20 years. I got out of there, never went back. Chicago kills that area. You're in rural areas. It's starting to Chicago. So do your treat versus stand your ground. Sometimes it's spelled like that, not purposefully, right? And so states will fit somewhere on this range here. Sometimes you'll have closer on this side, you'll have the castle doctrine kind of thing, where that's if you're in your own home, your home is your castle kind of thing. Basically what this is at its most extreme is if someone's aggressive with you, you don't have to back down at all. If they continue to escalate, you can let them escalate all the way up to the point in time you can use deadly force to stop them. Right? That's good if you have a persistent person who's targeting you. Young probably haven't had that happen yet. At some point in time, if you engage the world on enough people, at some point in time, someone will choose to make you a victim for no other choice than whatever it is that's going through their head at that point in time. Right? Whenever you run into one of those situations, you don't want that situation to be dictated by that person. So this is where you want to be in that kind of a situation, because otherwise they dictate it. Over here, this is where you'd want people to kind of hopefully act, because someone kicks in your door, you don't have to kill them. Maybe you shouldn't. They might be under necessity and they might have some reason that they're there, right? They might be confused. That happens quite a bit. Opened the door to the wrong apartment. Wasn't my apartment. I got confused. I walked in the dog or whatever. I'm back from a party, whatever. Right? Those things happen. Do your retreat. Where you're at in terms of those states is you are legally obligated to make any and all efforts to escape the situation before using force. Someone kicks in your door, you leave. They can have your stuff. That's not good, right? Because if you're a criminal, all you want is their stuff, then all I have to do is use enough force, right? Same kind of thing that we have with, mentions fleeing felon thing here. We'll talk about that. Police chases, right? You chase someone because they're dangerous. We terminate pursuits when we catch them or they're too dangerous, right? So if they drive dangerously enough, the incentive there is drive more dangerously, right? Who was that? They were talking about that in terms of there's one name for it. Cobra effect. That's a different thing. We'll talk about that in methods. You've incentivized crime over here. That's why those states have such issue. What they're trying to do is they're trying to use the law to deal with violence. Laws don't do that. They only restrict those who abide by it. You use it against those who don't. If you're trying to use it to restrict criminal behavior, it doesn't work that way. That's not what it does. So, best situations, you're over here, you act like over here. Worst situations, you're here, and you act like you're over there. Because otherwise, any way you cut it. If you're over here and you're in a situation where you have to stand your ground, get ready for a legal battle, and you might lose. If you're over here and you act that way, that's actually not all that bad so long as no one else is acting badly. But if there's a whole bunch of people acting badly, that goes off like war. That's not good. The fleeing felon and defense of personal property. Where we have that line set now is it has to focus in on that imminent death or serious injury, grave injury, let's say, life threatening. If you can't establish that that's in the risk there, And you can't use it. Meaning you have to establish that person's dangerous, that kind of a thing in that moment. Fleeing felon rule was from 1970s. Basically, if you are committing a felony, I can stop you by whatever level of force I want to as a police officer. Didn't have many felons in flee because I knew they're risking their life. Right. The problem is if you have someone who's overzealous, it's like overzealous. What does that do? Tennessee versus Garner is what that one was. That's someone being shot in the back of their head while fleeing a house that they just burglarized for $5-10 in a purse, something like that. Yeah, that's not the value of a life. Sorry. So the math there was wrong. So we had to revise it. Okay. Intoxication we kind of talked about. If it's voluntary, you're still responsible. If you're drugged, nope. That's a different thing. Right? You'll see, of course, intoxication is going to be pretty heavily reflected in statutes. That involuntary aspect's not as well reflected. It's something that happens, but not something that we talk about too much. Consent and condemnation. Euthanasia, condemnation. If someone agrees to be victimized, is it still a crime? I don't know. This is one that we don't know in society either. For example, right now, the first person to use a suicide pod just did so, was it yesterday or a couple days ago? Did you guys hear about that? Yeah. So after following the weird stuff, because it's a weird one, Canada, they have, I think it was Canada, it's a Canadian company that started. I know Canada's where I first heard about it because they were piloting it there. Canada's laws related to euthanasia and suicide. They'll help you if you want it, if you've got reasons to. Among those reasons, depression. Some taking care of people thing. Yeah. Like, yeah, you're really taking care of people. Yeah. Age ranges there. They've been talking about increasing that to include children too. Those under the age of 18. Yes, it's like those are changes that are happening. Keep an eye on that stuff. It happened over in Europe, if I remember correctly. I think they said it was in Germany. Out in the woods. It was a United States citizen, 60-something-year-old woman decided to climb up into that pond, and it just cuts off the oxygen, so you slowly suffocate. You have other gases, so you're breathing. You don't realize you're suffocating. That's it. Yeah. And so it's like, that's where we're at now. Historically, whenever I was in your position, the person they talk about was a guy by the name of Jack Kevorkian. Does that name sound familiar? No. Also known as Dr. Death. Basically, what he would do, he would take people who are terminally ill, and if they wanted to die, he'd set them up. Basically, it was a gravity IV system. You got your arm up, IV's in. As soon as you put it down, gravity's going to pull the fluids down into your vein, and you'll die pretty quickly. Painlessly, quickly, right? So he's not technically killing them. He's helping them, right? Is that something we should allow? Right? That's a hard one. We don't know. His story was a little bit different. He ended up going to prison for actively killing someone as they were dealing with him. Eventually, he created a video because he'd always record the things too, so to show I didn't do this. I just set them up. They did it. You don't have any statutes that deal with this, and so it wasn't anything necessarily criminal. And they start moving that direction. Eventually, what he did is he just found somebody and injected it to him directly, so that way they punished him for murder. I don't know if that was him trying to keep the door open or what exactly was going on there, if he was just tired of it. But now society's starting to say that that's okay. Don't know. Moving in different directions there. We'll talk more about it when we get to murder. So let's talk about life we have there. All right. PTSD, stress disorders. Just think we've already had emotional distress as a factor. This is going to be the medical distinction, the medical diagnosis associated with such long-term correlates. All right, here's where I get into the statutes. Yep, intoxication is not a defense. Subjection to spurious exonerates, that kind of thing. So duress, that kind of stuff. physical and deadly force, PTSD. Cool. And so next time we should be able to start talking about likely death. Cool. All right, excellent. That makes it for today. I hope to see you at 1 o'clock. If I don't, I'll be very sad. But I'll see you maybe Monday next week. I don't know. We're waiting for an announcement. I can't remember when we take off for right check. Tuesday. Okay, so we'll meet Monday. Excellent. Cool. All right. And with that, I'm gonna say adios for today. Bye.